Hello and welcome to PSN Speak. Thank you very much for subscribing to this channel. Those of you who have not yet subscribed, please do subscribe now. That gives me a great encouragement to bring you more of these kinds of videos. In my previous two videos, they were on Provident Fund Pension. I should thank you for your comments, valuable suggestions. Of course, there were also some questions. Questions were more on my Telugu version, Antarardham channel. And one of the suggestions was to make a video exclusively on the Supreme Court judgment. That is what I am doing now here. I am trying to comment on that. As for other questions, I am going to make another video and bring it to you soon, and codifying all the questions and answering them question by question. This one is confined to the judgment, and before beginning this, let me assure you that I am not going to use any technical jargon, no legalese. The purpose is to speak in plain English, simplest possible terms to be understood by everybody, and to know what is the benefit that we are getting or whatever the effect that is there out of the Supreme Court judgment. The Supreme Court judgment which came on November 4, 2022, the three judges bench, Chief Justice Uday Umesh Lalit, Chief Justice that day, Justice Anuruddha Bose, Justice Sudhanshu Dhuria, on employees Provident Fund Pension appeals, rates before it, whatever. But before that, we need to know, though briefly and quickly, the background of this case coming before the Honorable Supreme Court. As you know, the Employees Pension Scheme was introduced in 1995. Before that, there was a scheme for employees' family pension, but this is the first ever employees' pension scheme brought by the Employees Provident Fund Organization. When the employees' pension scheme was introduced, the statutory wage ceiling was 5,000 rupees. Those who were drawing above 5,000 rupees, their pensionable salary was linked to 5,000 rupees, whereby, as I have shown in my previous video, the highest anybody got with 35 years of service could be 2,500 rupees, or when it was raised to 6,500 rupees, then it was half of 6,500 rupees in cases where one worked all 35 years. But after some time, that was in 1996, there was an amendment, para 11.3 of the Employees Pension Scheme. We have to remember this 11.3 because this repeatedly occurs in the judgment and maybe in our discussion also. So on 16th March 1996, under 6A of Employees Provident Fund Act 1952, the members, Employees Provident Fund members were allowed to contribute on higher sums and get entitled for a pension on higher pay, provided the employees paid employees contribution and employers paid employers contribution on the higher wages. That was optional, it was not statutory. Again, is the statutory limit if any employer paid, I am repeating, on higher salaries, and of which naturally 8.33% goes to the pension fund out of employer's share of contribution. In such of the cases, if they give option, they were entitled for higher pension. But this was not publicized enough, as the employees claim. They did not know that there was scope for higher pension. And those who did pay, their employers paid on higher wages above the ceiling. Some of them did not exercise their option because they didn't know that there was a need for exercising option. And when they exercised the option towards the end of their career, that was refused by the Employees Provident Fund Organization. Then they had to go to the court and say that our employers paid on higher wages. Then first they went to the Himachal Pradesh High Court, and Himachal Pradesh single judge bench of the High Court accepted the employees' claim, But then, as usual, the Government of India, Provident Fund Organization naturally going up. They went in appeal, and in the division bench rejected the employees' claim and upheld the Provident Fund Organization's claim that there was a cut-off date. Then employees had to go to Supreme Court with the same claim, and Supreme Court 2 judges bench. That particular case is known as R.C. Gupta case. R.C. Gupta case, the court went into detail and said what employees were claiming was right, and it allowed that they can give options. Subsequently, there is no cut-off date for options. As things stood thus, then in 2014, we need also to remember this 609E 22 August 2014 notification. Even if you forget this, enough if we remember 11.4. Para 11.4 of the pension scheme. 11.3 is for the pension before 2014. 11.4 for higher pension after 2014. So through this 11.4 or this notification, the statutory ceiling was raised to 15,000 rupees. Together with this, certain conditions were also brought in. One is the employee should pay 1.16% of their wages to the pension fund if they opt for higher pension over and above 15,000 rupees. That was one condition. And second, the computation method was changed. Pensionable salary used to be computed taking into account 12 months salaries average. This notification said that the computation would be based on 60 months salary, 60 months average salary for Provident Fund purposes, basic plus dearness allowance. Of course, there is a mention of retaining allowance and all that. Retaining allowance is given to those employees who are not working on account of closure of a factory, and the factory is giving some retaining allowance. So not going into those details, broadly it is enough if you understand that the salary means the basic salary and dearness allowance. Then more importantly, the employees who are contributing more, the employers contribution also more than the statutory ceiling. The employers and employees should exercise a joint option, and that option should be within 6 months from the notification. And if for any reason, if they could not exercise the option with the approval of the Provident Fund authorities within another 6 months, that means nobody can exercise option beyond 1 year. Aggrieved by these conditions, the employees and their representative approached the courts. In particular, Kerala High Court, Delhi High Court and Rajasthan High Court. All these courts accepted employees' claim and they set aside the notification. What is that notification? 609E 22 August 2014, raising 15,000 together with these conditions. Then naturally the Provident Fund Organization and the Government of India went in appeal before the Supreme Court. That is this 3 judges bench, and that is the judgment. Now let us look at the main part of this judgment one by one. Number 1, the Supreme Court held GSR 609E 22 August 2014 legal and valid. Number 2, the amendments brought in apply to the exempted establishments also. In my previous video, I have explained what are exempted establishment, what are unexempted establishments. So here it applies to everybody who is a PF member. And 3, employees who exercised option under 11.3 of Employees Pension Scheme 1995, which means before 2014, and continued in service on 1st September 2014, they will be guided by para 11.4. That means it applies to them. They can exercise option and benefit. Then 4, those who did not exercise option under 11.3, that is before 2014 scheme, they would be entitled, and the right to exercise option is crystallized in R.C. Gupta case judgment. The Supreme Court accepted the R.C. Gupta judgment insofar as the cutoff date and exercising of option. Since there has been a lot of confusion, uncertainty, crashing of the notification, Supreme Court as a special case, exercising its special powers available under Article 142 of the Constitution, directed that option can now be exercised within 4 months from the date of the judgment. The judgment is 4th November 2022. 4 months from then, those who are eligible can exercise their option. Then 5. Employees retired prior to 1st September 2014 without exercising option under 11(3) pre-amended scheme have already exited. They did not exercise the option. They would not be entitled to the benefit of this judgment. 6. Employees who have retired before 1st September 2014 after exercising the option under 11(3) of Employees Pension Scheme 1995, which means the scheme existed before 2014, they will get the benefit of para 11(3), the scheme that existed before. 7. The court held that the seeking contribution from employees 1.16% above their statutory wage of 15,000 rupees is ultra vires constitution. That is illegal. But it suspended this part of the order for 6 months because the pension sum and all that are calculated based on this contribution. The scheme has to run. So for 6 months employees need to pay 1.16%. But within the given time, the government should bring in changes necessary, modify the scheme. Because it is ultra vires the 1952 Act, unless there is legislative change, court is not advocating for any legislative change. If there is no legislative change, any changes administratively, even including raising the contribution from the employers, that doesn't offend the 1952 Employees Provident Fund Act. Whatever government does, let it do. Till such time it does, or up to 6 months, employees will pay 1.16% on the wages above 15,000 rupees. And this is only a stopgap arrangement in terms of the amendments, whichever the government going to bring to the scheme. This sum will be adjusted. 8. No flaw in altering basis for computation of pensionable salary. Instead of 12 months average, the change is 60 months average. So the court did not find fault with this. So the 60 months norm will continue. 9. The court is in agreement with the view expressed by the 2 judges bench of the Honorable Supreme Court in R.C. Gupta case. So the court directs the authorities to implement R.C. Gupta judgment within 8 weeks as per the directions in this case. 10. The contempt petitions and civil appeals etc. are disposed of. So in summary, this is the judgment, and I told in the beginning I am going to get you another video answering the specific questions raised in response to previous 2 videos and maybe to this video. Also I am planning to bring a small video on exercising the option very soon. Thank you very much for watching the video. See you soon. Thank you.